real estate condition report. And just reminders on how it relates to having our sellers fill them out. And general, just the generalities of the real estate condition report. So again, it is required in the state of Wisconsin for all sellers, unless they are exempt, and we will go through the exemptions in a minute, to fill out a real estate condition report. So this is a state statute. The purpose of the real estate condition report is to note any defects about a seller's home, to share with the buyer. So this is the first page of the real estate condition report. Another note about the real estate condition report, we as licensees are not touching the real estate condition report at all. We are not filling any part of it out. We can get into a lot of trouble if it has been learned in a post-closing dispute or in a court of law that we had any hand in filling out the real estate condition report. So, but starting at the top, so the condition report concerns the real property located at, and then you would put in the address in here. The seller will put their address in here, and then they'll indicate the municipality type. So by striking whether it's a city, village, town of, and then they'll indicate their the municipality at the following line, county of, then they'll name the county on the third line. This report is a disclosure of the condition of that property in compliance with section 709 of the Wisconsin statutes as of, and then they'll put the date that they're filling it out. It is not a warranty of any kind by the owner or any agents representing any party in this transaction, and is not a substitute for any inspections or warranties that the parties may wish to obtain. So that's a good disclaimer for the buyer, right? So this is what the seller has knowledge of, but it is not a substitute for an inspection. So a buyer would still likely want to get an inspection.
I'm gonna put this on.
Oh, let's mute, guys. So a buyer who does not receive a fully completed copy of this report within 10 days after the acceptance of the contract of sale or option contract for the above described real property has the right to rescind that contract, provided the owner is required to provide this report under Wisconsin statute chapter 709. Fully completed copy of this report. I want to highlight that here. So a fully completed copy of a real estate condition report indicates that every single question has been answered. So it's yes, no, or non-applicable. We as licensees, as it relates to the real estate condition report, our job is to, once we have seen, or once we've received a copy of the filled out real estate condition report from the seller, we can go through and just make sure that every single question has been accounted for. There could be rescission rights for a buyer if they do not receive a completed copy of the report. So again, we as licensees can just at least review, and if we see that a question has not been answered, we can go back to the seller and say, oh, you forgot one. So that's our duty when it comes to this real estate condition report, as far as having our eyes on it. We can't make comments on how they filled it out, but we can make comments on the completeness of the report. So following that, notice to parties regarding advice or inspections. Real estate licensees may not provide advice or opinions concerning whether or not an item is a defect for the purposes of this report, or concerning the legal rights or obligations of parties to a transaction. The parties may wish to obtain professional advice or inspections of the property, and to include appropriate provisions in a contract between them with respect to any advice, inspections, defects, or warranties. So this is a good paragraph to point to when a seller is asking how to fill it out. So we cannot give or provide advice or opinions on how to fill out the real estate condition report. If they want advice, legal advice on how to fill this out, we need to point them back to their own attorney. As I was saying to Rob this morning, when I have questions about how to fill out a real estate condition report, what we can do is provide examples of real estate condition reports. So I have done that for a seller. I've actually provided the condition report that I filled out on my own home, because I was detailed and I used a separate sheet of paper for overage and just really spell out, how things were taken care of when there was a defect. Not only did I describe any current defects, but I described defects that I had remedied throughout the years of my ownership. So I've shared that, for example. So please feel free to do that. If you have a prior real estate condition report, you can share examples of how a real estate condition report has been filled out. The question on whether or not something is a defect, we cannot answer that. We only can point them back to the definition of a defect. Any questions so far? Okay, glad to see more of you on. Oh, there's a lot of you on. That's great. All right, moving on. So this, again, we're continuing on to the first page of the condition report. And this is information for the owner. So when you're having them fill this out, just making sure, please read the first page. It will give instructions and definitions of terms that you'll find in the report. And this will guide you on how to fill it out. So we'll go over this. A1, in this form, aware means the owners have notice or knowledge. In this form, defect, and here's the definition of a defect, means a condition that would have a significant adverse effect on the value of the property, that would significantly impair the health or safety of future occupants of the property, or that if not repaired, removed, or replaced, would significantly shorten or adversely affect the expected normal life of the premises. A3, in this form, owner means the person or persons, entity, or organization that owns the above described real property. An owner who transfers real estate containing 1 to 4 dwelling units, including a condo unit and timeshare property by sale, exchange, or land contract, is required to complete this report. So that's a good note to make here. This is for 1 to 4 family properties. So if there is a commercial property or a 6-unit, 8-unit apartment building, you would use a commercial real estate disclosure. An exception, now here it describes exceptions to an owner who are exempt from filling out the real estate condition report. So an owner who is a personal rep, trustee, conservator, or fiduciary appointed by or subject to supervision by a court, and I'm going to highlight this word, and who has never occupied the property transferred, is not required to complete this report. So it's got to be one of those described entities, and they have never occupied the property. So I'm going to go ahead and point out Rob this morning. I was helping Rob with a listing coming up. It's a trustee situation. Is a son selling a property for his deceased parents. He lived on the property 35 years ago. He still has to fill out the real estate condition report, even though it's been 35 years since he lived on the property. So That's a common mistake when it's a set of children selling it for their parents. If at any time they've lived on the property, they still need to fill out the real estate condition report.
Can they, excuse me, can they refuse to complete one? Because I have a situation where it's in the home is in quite a bit disrepair, and I think he's just overwhelmed and he refuses to fill it out.
He can, and so we'll point him to the seller refusal to fill out a condition report. What would be different though, in this case, is that he wouldn't be able to cite that the reason why is because he's exempt. So, and I'd have to look at how that form reads. I can't remember if there's blank line, and we could look at it in a minute, or after this is over, but if there are blank lines for him to fill out on reasoning for why he's refusing to fill it out. But there is a form in lieu of the condition report that we can give to him. Absolutely. Okay, A4. The owner represents that to the best of the owner's knowledge, the responses to the following questions have been accurately checked as yes, no, or non-applicable to the property being sold. If the owner responds to any question with a yes, the owner shall provide in the additional information area of this form an explanation of the reason.
That's what I have at the back.
You
Just
plug the
pluggy
thing right
thing.
back in.
Yeah.
Let me just mute everybody. Okay. All right, I'm going to read that again. So if the owner represents to the best of the owner's knowledge, the responses to the following questions have been accurately checked as yes, no, or non-applicable to the property being sold. If the owner responds to any question with a yes, the owner shall provide in the additional information area of this form an explanation of the reason why the response to the question is yes. So that's another thing, an item that you can review once you received a condition report filled out by your seller. So if you notice that there has been a question that was marked yes, and they didn't give that additional explanation in the additional information area, you can point back to them and say, we need to have an explanation for the reason why you responded yes to this. So that's another thing you can do when reviewing this. A5, if the transfer is of a condominium unit, the property to which this form applies is the condominium unit, the common elements of the condominium, and any limited common elements that may be used by the owner of the condo unit being transferred. So yeah, information for the condo owner, they're going to fill it out based off of the unit itself and any common elements of the condo, and any limited common elements that may be used by the owner. So if they have questions about that, you can point them to A5. The owner, A6, the owner discloses the following information with the knowledge that, even though this is not a warranty, prospective buyers may rely on this information in deciding whether and on what terms to purchase the property. The owner hereby authorizes the owner's agents and the agents of any prospective buyer to provide a copy of this report and to disclose any information in the report to any person in connection with any actual or anticipated sale of the property. So this is, a statement right in there that is allowing us as agents to share this with any prospective buyers. Caution, the list of defects following each question below are examples only and are not the only defects that may properly be disclosed in response to each respective question. So in the real estate condition report, when it's asking a question about a defect, it does give examples, and it's not just limited to those items. If there's conditions beyond those listed, they need to be indicated. So generally speaking, in all transactions, the broker, so that's us, is to inspect the property prior to listing it and to ask the seller for a written statement of the property condition, generally the real estate condition report. The seller completes the real estate condition report, the directions and the definitions in the record, and advice of legal counsel as needed. Let's see here. Wisconsin statute 709 requires a residential seller to complete the record, whether they are broker assisted or for sale by owner, or risk rescission. So that's a good thing to point out here, is that if it's a for sale by owner, and you might run into this out in the marketplace, if you as a buyer's agent are helping a buyer with doing a purchase on a for sale by owner, we are able to provide a copy of a blank real estate condition report for that for sale by owner seller to fill out if they don't already have one. So just because they're for sale by owner does not make them exempt from providing a real estate condition report. So Wisconsin statute 709 generally applies to all persons who transfer real estate containing 1 to 4 dwelling units, including condo units, timeshare property, and living quarters into commercial property. And then going back through the exempt sellers. So again, it's personal reps, trustees, appointed conservators, and other fiduciaries are subject to provision by the court, but only if those persons have never occupied the property. Real estate that has not been inhabited, for example, new construction. I'm going to highlight this one as well. So oftentimes we get a question about investors, flippers, the question on whether or not they're exempt from filling out the real estate condition report because they themselves have never inhabited the property. That's not how the sentence reads. It's that the home has never been inhabited, and that's only a new construction home. So new construction homes, developers are exempt from filling out that real estate condition report because the home has never been occupied or inhabited. A flipper, though, is not exempt. Just because they have never lived in the property doesn't mean that the property itself has never been inhabited. So they must still fill out the real estate condition report. And I just always have to make this comment. It's arguable that a flipper knows more about that home than anybody else because they have been in there working on it and developing it and flipping it. So they should be well aware of everything that's going on in that house. Transfers, so another exemption, transfers exempt from the real estate transfer fee. So if the real estate is transferred between spouses, and foreclosures, probate transfers, another entity would be churches are exempt when a church is for sale because they are exempt from the real estate transfer fee. If a seller is claiming he or she is exempt from completing the record, the broker may review the WRA seller refusal statement regarding condition or disclosure report. So Sarah, I can show that to you and I'll pull it up at the end here. It's available in zip forms and we'll give this to them in lieu of that condition report. Licensee disclosures. So once the seller provides the real estate condition report, the licensee compares his or her observations and knowledge to the real estate condition report. So if there are inconsistencies or the licensee thinks the seller's disclosures are incomplete or inaccurate, the licensee would make timely written disclosure of the material adverse facts as appropriate. Back to Rob, I was showing him a form this morning called a visual inspection report, which I will also show you guys that as licensees, we can use as a guide when going through the home. As part of our job when we're listing property, again, is to check out the condition of the home, each room, basement, if we if we know or if we see evidence of a leak in a roof, for example. So we're not inspectors, but if we observe something that appears to be a defect, we need to make note of that. A big example would be a crack in a foundation wall. So let's say you have a seller who has given you a real estate condition report that does not disclose a defect in the foundation, but during your listing appointment, you observed a crack in the wall. You would go back to the seller and let them know that we need to disclose that. And if they are not willing to disclose it, that we need to
Yeah, I
disclose
know,
it.
I have one. I have one.
I don't know why we'd be unmuted.
Hey, Steph, can I ask you a question about that?
Absolutely.
Um,
Oh, Bethany, unmute yourself.
okay, sorry. You know how we're told that we're just supposed to give a seller the condition report and not like tell them what to do or how to guide them. So if we get that report back and it doesn't disclose, let's say, that crack in the foundation, and we say, hey, when I looked, I noticed there's a crack, you might want to rethink that, or, how are we supposed to really kind of handle that?
I guess where I kind of headed off, well, I'll answer it both ways. So my process is when I'm going through a home with a seller, I'm having them take me through the house, and then at that point, I'm kind of going through and talking through the idea of the concept of the real estate condition report, that there's going to be something that there's a form that they're going to need to fill out. And I'll, if I see a crack in the wall, I'll say, like, here's an example of something that you would need to disclose. There's a crack in this wall, right? So I kind of use that opportunity to make an example of what the real estate condition report is used for. If it gets to the point where you haven't been able to identify that ahead of time, yeah, tactfully, how would you say? And I've been put in that position before. I always just go back to, as a licensee, I will need to disclose this if we don't put it on the real estate condition report. And I would just be describing the condition that there is a crack in the wall, but we don't know anything beyond that except that it is a crack, right?
Right. Yeah. Well, and plus I know I've had the conversation be like, it is in your best interest to disclose anything and everything that it actually protects you, from a buyer finding something and coming back even later on after the sale closes.
Absolutely.
We had a situation this morning where one of our agents has a new listing, got the record signed by the seller. And then the son, adult son of the seller, said, did Dad mention the leak in the garage roof? And so he looked it up and it's not on the real estate condition report. Our agent called the seller and said, something about how much do you know about this leak in the garage roof? It should be disclosed probably. And the seller said, that's nothing, it has nothing to do with the house. And so I advised our agent to fill out the material adverse facts. I said, just be safe than sorry.
Yeah.
Full disclosure is always better than questioning it. So, and, sometimes that irritates the seller mildly. But it is, like you said, Bethany, it's all about disclosure and protecting the seller, really. That's what this is all about, is protection for the seller.
Right.
Yeah, I think it can be a little tricky, especially in this market when we all want listings. We don't want to basically piss off a seller and lose the listing off of something like that. So.
And you can,
Yeah.
I've seen that happen several times.
Hey, Steph, I have a question. So if I know that there is the seller disclosed to me that they recently replaced the heating system, it's now it's now gas and it was before oil. So when we were in the basement, I said, okay, so where is the oil tank? Was that removed? And he said, no, it's buried under the driveway outside.
Hmm,
So that is, I mean, so that is something I know about. And that should be disclosed, correct?
yes, absolutely.
Okay.
Was it,
And what, go ahead.
well, I was just gonna ask, I mean, the follow-up question, and I don't know the rules explicitly on this, so I think if it's filled and abandoned properly, that's okay. So my next question to them would be, have you been in touch with the oil tank company to find out how to properly abandon this if you don't have to have it removed?
Especially if it's under a driveway.
Right.
Okay.
But
All
it
right.
might be the case that it has to be removed, and I don't know that, so that's why we need to ask that follow-up question.
Okay, and so that would be whomever converted the furnace. I mean, so somebody, so an inspector, somebody needs to make a call on whether or not that abandoned if the oil tank can remain and be abandoned and properly filled, or if it has to be removed. Would that be a true statement?
Yes.
Okay, thank you.
Another thing to take note of here is that oil tanks are subject to a state registry list. So as a buyer's agent, they're going to check that registry list to make sure that it's been removed or properly abandoned. Whoever the contractors who take care of that have to report that with the state and make sure that it's on that list. So
Okay,
it's a big deal. Yeah.
thank
So,
you.
yeah. So yeah, I would start with the contractor. Another resource that I'm always pointing people to is A1 oil tank removal. They're another good company.
Is
So
Earl still alive?
I think so, yeah. The last time I talked to him was last December.
Okay,
So,
well, that's good.
And I also wanted to make another comment about just with how to field these kind of questions on, a lot of times people will have the question of, this was an issue, but I took care of it. Do I need to disclose it? And we can't say yes or no to that, but what we can say is that it's best to over disclose.
Right.
Like anything that, and I kind of just like put it in the perspective of a buyer as well, like just, and put yourself in the buyer's shoes, even if this leaking foundation is not an issue anymore, I want to know if there's, I want to know how it was remedied, and that's for my own records going forward and,
Yeah, and that's a really good aspect to put yourself in the buyer's shoes. You don't want this to be a surprise to the buyer after they've moved in and the neighbor says something about,
yeah,
no, they had construction crews here all the time redoing the basement.
right.
And the neighbor doesn't know all the details, but enough to scare the new buyer.
Yeah.
So the more the buyer knows, the more they can fend off those surprises.
Mhm. And back to Joan's point about just, you're saving yourself from post-close, and Bethany's point, like you're saving yourself from post-close issues. So we don't want this to come back to bite you in any way. Okay, moving on. If the seller has never lived in the property but has received a pre-inspection report or any previous reports or evidence of work done, the information can be attached to the record or itemized by condition on the condition report. Full disclosure of any information on a property protects the seller and the firm, of course. If a defect has been corrected, repaired, it is good business practice to record that information. We're just kind of repeating what we just said, but record that information and the date of correction in the condition report so that there's a paper trail from the seller. I want to go back to this first paragraph. If there's a pre-inspection report, so it has been common practice, I feel, more often in the past couple of years where listing agents are encouraging sellers to just get pre-listing inspections done. And if that's the case, it absolutely can be attached to the real estate condition report. And we would all love that if we had pre-listing inspections done. And you can just the seller can just point right to the inspection report and say, please see attached. And then it's all right there for the buyer.
I have a question about that over the weekend. It was a pre-inspection, but it was done 2 years ago. Can that be attached as a pre-inspection report? I said, yes, but a lot can happen to a house in 2 years. It can be attached, but, citing the date that it's really 2 years old, it's not
Yeah.
current.
I probably wouldn't call it a pre-listing inspection report, but just inspection
No,
report from.
Previous, right.
Yeah, previous inspection.
Steph, I
Yeah,
have a
I think
question.
I had a listing last year where, the owners had only lived there for 2 years and they just used the condition, or they used the inspection report. They just like attached it to their condition report and then they attached that, but then they also cited defects that were new since the inspection
Right.
or since they purchased and the time that they were selling it.
Steph,
So,
this is Rob. I have a question as well.
all right.
So we spoke earlier about my sellers having a home inspection, and we talked about, mentioning home inspection.
Mhm.
Sometimes I've seen where a loan can be an issue when you tie in the home inspection. Is that I guess it's somewhat a fear of mine with tying it in through the record?
I guess I completely understand your concern. The concern lies more when there is a inspection done as a part of the offer and then supplying that inspection report or like referencing that inspection report at any point in the amendment exchange. I have yet to see, though, an issue come up from an attached inspection report to a real estate condition report. So I guess I don't know how to answer that. I think that if you want to get, if you have a fear about that, maybe you go to a trusted lender and ask their thoughts. But also, if a seller, remember this, if the seller wants to attach the real estate condition or attach the inspection report, it's their choice and their choice on how they're filling out the condition report. So
with sending a accepted offer to a lender, does the record need to go with? Is that part of the offer in the lender's eyes?
yes.
Okay.
Because it's attached to the offer. So yes.
Yeah. Okay. All right. Thank
I
you.
guess, Rob, I definitely understand your concern. I have yet to see that it be an issue when it's attached to a condition report. So
Yeah. In this scenario, I mean, he took care of everything that was on the inspection report, so it won't be a problem, but it made me think about future
sure.
kind of things. All right. Thank you.
Yeah, of course. So let me go to, let's see here. Forms. So I'm going to show you guys a couple of docs here that you can use. So I'm going to show you this one. This is the listing selling agent inspection form. So I think I was telling Rob this morning, this is not required per our per Keller Williams requirements. We highly encourage it though. to use this visual inspection form. So as part of like the checklist that you're bringing to your listing appointments, you know, we're always taking notes, right? And this is a good form to use in lieu of just a blank piece of paper, you know, as you're going through the home. You know, I'm doing it, you know, when I'm going through a house, when I'm having the seller take me through the house, I'm looking for, you know, the things that the seller has done to improve the home. And I'm also asking them about any conditions of the home that they've observed, right? So it kind of just all is coming up in conversation at the same time, and you can use this checklist to make notes, right? So this is the checklist that you would use when comparing it to the real estate condition report that you're going to receive later on from the seller to just like check against, you know? So going back to that crack in the foundation, like you could lower level defects observed, say crack in the wall, right? And if you noted a crack in the wall when you were going through it with the seller, and then the seller doesn't disclose that on the real estate condition report, you can say, oh yeah, remember that crack that we talked about? I don't see that on the real estate condition report. So I think this is a really good form to use. Again, not required, just highly encouraged.
Also notice on the form, garage is included.
Yeah,
A lot of times sellers will argue, you know, sometimes about the condition of the garage. It has nothing to do with the structure of the house. It doesn't mean that the garage is attached or detached. This is saying we should really be looking at the condition of the garage as well.
that's absolutely, I mean, I would never question it. That's absolutely a part of the property, right? And a garage, having the existence of a garage affects the value of the property. So,
Right.
oops. Okay, then, so one more comment about this form. This is not, if you do fill out this form, this is just your internal document. You do not share this with anybody. It's not that you would upload this to MLS. This is just for you and the brokerage, right? If now we're going to take that crack in the foundation, if the seller does not want to amend or does not want to disclose this crack in the wall as defect, then this is where we would use the disclosure of material adverse facts form. There we go. So it might be the case where we have to fill out disclosure of material adverse facts forms ourselves. And this is the form that you would use, and this is what you would provide to buyers. The official form that you would use to state the defect. So I am licensed in the state of Wisconsin as a real estate broker or salesperson. You'll strike one. Wisconsin law requires real estate licensees to make prompt written disclosures to buyers and sellers regarding material adverse facts and regarding information suggesting the possibility of material adverse facts. In other words, the law says that I should make sure you know, I love this because it's like plain English. In other words, the law says that I should make sure you know about certain possible problems that have not yet been reported to you by the other parties, licensees, or professional inspectors. An adverse fact is a condition or occurrence that is generally recognized by a competent real estate licensee as having a significant adverse effect on the value of the property, as significantly reducing the structural integrity of the property, or as presenting a significant health risk to the property's occupants. An adverse fact also includes information that indicates that a party is not able or does not intend to fulfill his or her contractual obligations under the offer to purchase. An adverse fact is material if a party indicates it is significant to them, or if it is generally recognized by a competent real estate licensee as being significant to a reasonable party, to the extent that it would impact whether or not the party enters into an offer to purchase or the party's decision about what terms and conditions should be in the contract. As a Wisconsin real estate licensee, I am thereby obligated to, by law, to disclose the following information, and then this is where you would list it. Plainly state only the facts without drawing conclusions or making predictions. Attach supporting supporting reports and documentation. I like this statement for us as licensees. We're just stating what we see. I see a crack in the wall. I'm not making any or giving any opinion about it. I know nothing beyond that except for what I see. So that, just to give you guys peace of mind that you don't have to make any conclusions about it. So, just stating what it is, simply and easily. It is recommended that the sellers and buyers in this transaction obtain a professional assistance to conduct appropriate property inspections, testing, and other investigations regarding this information. Licensee in this transaction will draft inspection, testing, or investigation contingencies, amendments, notices, and other documents pertaining to the offer as directed by the parties. By initiating and dating below, I acknowledge that I received and read the disclosure form. So us as a licensee will sign it. We'll put our broker firm name, and then the parties receiving this disclosure will also initial and date it. Okay, so this is the form that you would use.
So that's the form that when a buyer puts in an offer, they are initialing whatever this form, acknowledging that they're aware of it.
If this is provided prior to an offer being written, yes.
Okay.
Sometimes.
So this could go under the documents tab in a listing.
Yep.
Okay.
Yep. Sometimes you might receive this after a accepted offer. So. Okay. Back. There was one more. Oh, the seller refusal.
Stephanie, real quick, what did you just say? Did you say that that form could be completed after an offer to purchase has already been accepted?
You might learn information.
Okay. So if you learn new information.
Yes.
Okay. Thank you.
Yep.
But be careful not to amend the record because it gives the buyer more rescission time.
Yes. Very important. Sellers. Okay, here we go. Sellers refusal to complete condition report. So they would fill this out. So I think Sarah, your seller would probably check mark box or line 18. So seller refusal to complete. Seller hereby acknowledges that seller has refused to provide listing agent with a completed record or a vacant land disclosure report or other seller's disclosure report for the above property. Seller understands this refusal may be disclosed to potential purchasers. Seller acknowledges seller has been advised that seller's refusal to provide this report does not release seller of any disclosure obligations under the Wisconsin statutes or common law. Seller should consult with legal counsel regarding seller's disclosure obligations in and as is sale. So since they're not exempt, they couldn't fill out or check any boxes 27 through 32. So they would just be saying flat out, I'm refusing to complete it.
Yeah, I had two listings where the seller signed this refusal and checked line 18. One of them was he had renovated this house, never lived in it, and it had been years since he renovated it to when he was selling it. And his point was, I don't know what's gone on in this house since I renovated. I don't want to be held liable. I'm just not going to sign this. And we signed it, and it was for the record for any buyer to see that he just didn't want to be responsible.
Mm-hmm.
And it didn't seem to bother anybody. The other one I had, it was property owned by a family member who lived in Colorado and hadn't seen the property and been in the property. Same sort of situation for several years, and wasn't gonna put their name on the fact that they knew anything about the property. And in both cases, buyer accepted the refusal and things went on.
So that is kind of the situation I have. It is a son, it is a trust situation. His mother passed away. But the home, I think he wants to sell the home as is because it just needs so much work. And he just doesn't know where he would begin to start disclosing things.
Right.
So, so if he chooses to sell as is, he can complete line, is it 18? Okay. And then as the agent, would I have to complete the disclosure of material adverse facts form then? Is the onus on me as the agent, the listing agent, to disclose what I see?
That's a good question. I think anything obviously material adverse fact, I think you still have the duty to disclose that.
Okay.
But I wouldn't get into, all of the checklists on a record. But anything, and in one of those listings that I had where the seller refused to, I did fill out a material adverse fact form because they had a flat roof over the garage, a rubber roof, and you could tell it was totally disintegrated. And I made sure that I wanted to point that out and did a material adverse fact. But I didn't go through the 1,000 other things that was wrong with the property.
Yeah, Sarah, that might be like, you're not gonna pull out a tape measure and see if walls have moved in the foundation. Again, it's kind of those just major obvious things. Right.
Well, I would think this is pretty common when you have a property sold as is, that the agent isn't going to be doing a fine tooth assessment.
That's never our job to do fine tooth.
Okay.
We just don't have that's beyond our scope, right?
Yeah, I mean, I would be able to say, yeah, I see chipping paint and I know that there is a buried oil tank. And it appears that the, roof could, I don't even know. I don't know about the roof. If I
But
saw it peeling,
the
but I don't see
statement-
anything.
The statement that the seller, who is not exempt, refuses to fill out any of those conditions, that's on the record. He's selling it as is, it's on the record, he's not going to disclose anything. And whether it's your duty or not, I think comes down to just basically common sense. If there's something that's smack in your face, obvious, list it just because you're doing your duty. And the seller certainly is not going to disagree with it, but he'd say, well, if you have to do it, do it, but I'm selling it.
Okay.
As.
Okay. Thank you.
Yeah. Well, we almost went the full hour, which is great. Do you guys have any just general questions? Okay. Well, next week there is no training. The office is closed. Celebrate Juneteenth Day. And then the following, let's just look here. Following week is on, I'm gonna pull it up. Defining defects and serving a notice. So this is good. So when it comes down to filling out a notice of defects, the proper way to fill it out. So,
And I'll be covering that one.
and Joan will be doing that, yep. Thanks, guys.